Hello, everybody, and welcome to another episode of Adamize. I'm here with Sahil Kapur from Talking Points Memo, and we're here to talk about a bunch of things today, but primarily about the Supreme Court and last week's same-sex marriage cases, for which we were both in attendance. How are you doing, Sahil?
I'm doing well. Thanks for having me here.
Well, thanks for coming. One of the things I think we're both sort of one of the things that you really sort of have to do when you start covering the Supreme Court is sort of predicting what happens or what's going to happen, which I think is sort of like a very dicey business, right? But in this, I personally found it really sort of difficult to predict what might happen in these cases, except to say that I didn't think that there was going to. There certainly didn't seem like there were 5 votes on the court to enshrine a constitutional right to same-sex marriage. But other than that, I wasn't really sure of anything. But you had a more certain take, and I'm interested to hear what that was.
Well, I mean, I would caveat this with saying there's, like, as you said, there's no certainty to any of this. But what it looked like to me was that there were 5 votes to kick Prop 8 on standing. In other words, to say that the case wasn't properly brought to the court, in which case, whether or not they vacate the Ninth Circuit's ruling, Prop 8 would be struck down, so gay marriage would be legal in California, but the issue would be left to other states and the voters of other states to decide, or perhaps the courts in other states to decide. As for DOMA, what I saw were 5 pretty clear votes to strike it down, and Kennedy being the swing vote, probably on federalism grounds. And if he decides to go that route, I can't imagine that the liberals wouldn't join him, at least in judgment, and maybe write separate concurring opinions. So that would be my...
So we should clarify for our watchers, just in case they're not up with the legalese. Basically, there's 2 same-sex marriage cases. There's one involving California's statewide ban on same-sex marriage, which was instituted by popular vote. And then there's this federal law known as the Defense of Marriage Act, which passed in 1996, which basically denies benefits to same-sex couples who are married, even in states, federal benefits, even in states where same-sex marriage is legal. So this question, with the Prop 8 case, it seems, you think they're going to kick on standing. And I personally, it seemed to me like they were actually... It seemed to me that the standing argument, when I was there immediately afterwards, I didn't think they wanted to kick on standing, but I'm interested to hear why you think they will kick on standing.
Well, the main reason...
Which sort of allows it, just to clarify, kicking the case on standing just basically means that they don't reach the question of whether or not there's a fundamental right to same-sex marriage or whether Prop 8 discriminates against gay people and violates their constitutional rights. They just sort of avoid answering the question on a legal technicality, and the previous ruling that as Sahil said, that a lower court came up with stands and basically means that same-sex couples in California can get married.
Right. So the reason I think they'll kick on standing is simply for strategic reasons. The liberals on the court probably don't see 5 votes to enshrine a constitutional right to marry, since Kennedy made clear at many points that he was not ready to do that he was uncomfortable with doing that. So it seems more like a strategic decision to say, well, we obviously don't want to uphold Prop 8 either, and the best we can get is to make this argument that this case was not properly brought before the court, which they can make by saying that California refused to defend the law. In other words, the Schwarzenegger administration when it passed, and the Jerry Brown administration now has refused to actually defend it in court. So they can say that people who are defending it now are not a proper party to do it. I think, as I said, it's mostly. Well, at least what I saw on the court were, or during arguments, were very skeptical questions from the 4 liberal justices, as well as Justices Roberts and Kennedy. Very skeptical that this case was even brought properly. And the other reason, I think, is that the liberal justices, whatever they may think about this, I think they were leaning towards... at least most of them, if not all of them, were leaning toward declaring a constitutional right to marry. They can see the polls, and they can see how quickly this is moving. So for them, I can very much see them saying, look, let's at least not take a step backward, and if we don't take a big step forward, the way the polls are looking, the voters will do that themselves.
I find this sort of standing question really weird, in part because I feel like, I know it's not legally this, but I feel like it almost sort of accepts the idea. If they kick on standing, it almost sort of says that a lot of the anti-same-sex marriage arguments are invalid, even though from a legal standpoint, it technically doesn't say that. But this idea that, they weren't directly harmed by the ruling overturning the ban on same-sex marriage sort of says nobody's harmed by it. I mean, I know that's not exactly what the Supreme Court would be saying, but I feel like that conclusion is almost difficult to avoid.
Right. Well, it's true. I think, if they were to kick this on standing, they'd have to do it in a pretty narrow way. In other words, they can't really say that if a state refuses to defend a law, then no challenge against it is legitimate, because that closes a lot of doors that, and I think Justice Alito...
Right. Any liberal or conservative administration in a state could pretty much invalidate a law by refusing to defend it, which is something that conservatives accused the Obama administration of doing with DOMA.
Right, and that would be very problematic. I don't think either side really wants that to happen in the long run.
Mm-hmm. One of the other sort of interesting Prop 8 questions was when I actually thought the DOMA, although DOMA is more likely to be struck down, I think, I actually thought the DOMA oral arguments, and this is another indication of how oral arguments mean almost nothing, I thought that the Prop 8 arguments went much more poorly for the anti-same-sex marriage side than the DOMA arguments. I thought the attorney, Charles Cooper, who was arguing in favor of the California's ban on same-sex marriage, sort of really got outmaneuvered by the justices, or sort of was put in difficult positions where he had to sort of try and slice the salami real thin in order to avoid saying something ridiculous, which is what the justices try to do to people who are arguing before them whenever there's a law that they don't like. In particular, there was this sort of extraordinary moment where Justice Elena Kagan said, Cooper was sort of linking marriage to procreation, and Kagan said, well, then could you ban? Would it be constitutional to ban people who are couples incapable of having children from getting married? And he said, no, we don't think that would be unconstitutional. Well, it's like, that's sort of the crux of the question, right?
Right. Yeah, absolutely. I agree with you that the lawyer defending Prop 8 didn't do a very good job, and at many points he stumbled. He was sort of back into a corner, and I think it's really ironic that this is happening at the same time that so many people around the country are also coming around to this view that it just doesn't make a whole lot of sense to treat gay people differently, whether it's marriage or federal benefits or what have you. And I think what we saw in the court was sort of a microcosm of where all this is going.
Yeah, I mean, this question of I think and this is sort of. There was a blog post by Ross Douth out of the New York Times earlier this week where he's saying, obviously same-sex marriage opponents didn't imagine the whole marriage procreation link. Mm-hmm. But I think that sort of doesn't get you all the way, right? Like, if you want to argue that same-sex couples should be denied the ability to marry because marriage is for procreation, we haven't ever previously prevented people from getting married on those grounds. There's never, or at least the United States, it doesn't have a history of banning marriage between couples who can't conceive, who are opposite-sex couples. So if you say, well, gay couples can't procreate, marriage is for procreation, that actually doesn't get you to the point of saying, well, then same-sex marriage should be illegal, precisely because we've never, even if marriage is for procreation, we've never before said until same-sex couples wanted to start getting married. We've never sort of before said that. But if you can't procreate, then you can't get married at all.
Right. I agree, and I think it displays the extent to which this is sort of a reverse-engineered argument. You start from the conclusion that we want marriage to only be between man and a woman, and then you find reasons to arrive at that conclusion. And the reality is that marriage has constantly evolved throughout its inception, way back when. And this is sort of the latest stage in that evolution.
Right. I mean, and I also, there's when Cooper was making this argument, I think Clement actually made this argument too. There's a real sort of interesting default position that both attorneys took as far as same-sex marriage was concerned, which is that the Supreme Court shouldn't interfere because the political process is already handling it, by which, they sort of meant we're losing, so don't interfere with this because it'll be much more legitimate even if you think the same-sex marriage side should win, then the best way to do that is through the political process because it's more legitimate than a court fiat. So even if you don't like my arguments, you should say, well, if the court does this, it's going to be terrible. I think the sort of the argument, the liberal, I'm worried about how this is going to turn out argument is the Roe decision, which I think the backlash to which I think is often overstated. But this it's sort of interesting to hear. It was interesting to see both attorneys arguing politically, at least, that they're losing.
It was basically concern trolling, right? This whole notion that you shouldn't, don't take a big step forward on this issue through the courts. Just let the voters do it. In other words, you had written about this. It's sort of like saying, just let us lose in peace, or let us lose with the voters. But to take the obvious parallel, I don't know that there's any evidence that the Loving decision, did any harm in terms of public opinion or had any backlash in terms of support for interracial marriage. I don't think that there's any reason to believe that that the court taking a step where public opinion is clearly moving in a certain direction would harm that cause. And a lot of people make the comparison to Roe versus Wade, which I don't think is accurate because that's a moral issue where there's very little evidence that there's a generational gap, that there's a generational difference. Millennials,
or that things are moving in one direction
right,
or the other.
So if you look at the polls, millennials oppose abortion in about the same numbers as most of the older folks today, and it's just not the same it's just not the same kind of question, and there's no clear tide in public opinion moving in one direction or another. So you can see how Roe versus Wade catalyzed a movement there, but it's difficult to see any sort of a meaningful backlash, or at least a lasting backlash to this, because even for Democrats, it's pretty much become a litmus test, and more of them we've seen in the last week or two have come out for same-sex marriage, and Republicans are also starting to move in that direction. You saw Portman and you saw Mark Kirk over the last couple of weeks come out, so it's hard to imagine anyone making that big an issue of it on a national level.
Yeah, well, I'd say two things about that. I think the interracial marriage question is interesting because when the Loving decision came down, most Americans opposed interracial marriage.
Right.
They opposed marriage between whites and blacks, and not by a small margin either. This was pretty taboo in terms of whether or not they actually thought people should be able to get married. They personally were certainly opposed to it. I don't think that a majority of the country actually became supportive of interracial marriage until the mid-90s. It was an incredibly slow process of acceptance. And this is for interracial marriage, which the activists against same-sex marriage are like, oh, that's a no-brainer. It's nothing like same-sex marriage, which is a much more difficult question. When actually, from the point of view of public opinion, interracial marriage, was actually a much more difficult question in terms of whether or not people liked it. Certainly before, public opinion in favor of same-sex marriage now is way, way, way above where public approval of interracial marriage was in 1967 when the Loving decision came down. So the idea that if you make a decision like this, it leads to an inevitable and eternal backlash isn't really true. Public opinion on interracial marriage continued to evolve despite striking down the ban. And as far as Roe is concerned, it's sort of a lot of liberals have made the argument that Roe was sort of counterproductive in the way that it was reasoned. Ruth Bader Ginsburg, who is on the court now, has said it should have been decided on equal protection grounds and not on this sort of right to privacy thing, and there's been a lot of liberal critics of the sort of legal reasoning of Roe, which made abortion legal in the United States. But I'm not, this whole question of a backlash. It's sort of the question is whether or not these forces were against legal abortion were already massing anyway, and whether or not they would have been a significant force in politics independent of the Roe decision. And I think there's a pretty strong argument that that's the case. And that this would not had the Roe decision been more narrow, I don't think it would have stopped the backlash. Right. And I don't think that people really care about the legal reasoning behind decisions. I mean, I think some people care. I think an elite care about the legal reasoning behind decisions, but I think most people, are mostly concerned with results, what the actual impact, what the decision actually does.
I agree with that. I think, more so than actually than necessarily catalyzing people to a viewpoint or to to any sort of activism they wouldn't have otherwise been engaged in. What the Roe decision did was to clarify that these are our targets and these are the people. It just turned the Supreme Court into a piñata and made them an object to rally around. So that was sort of the immediate impact of that, and and you saw for a generation.
Well, it was certainly influential for the conservative legal movement that then put all the conservative justices currently on the court, right?
And that was a product of other decisions too during the Warren Court. I don't think it was just Roe. I think there was Miranda, and there were a number of decisions that really rubbed conservatives the wrong way and helped them catalyze this movement. At the same time that conservatives were ascendant nationally, not just in the legal realm.
I think one of the interest. I mean, the DOMA case as opposed to the Prop 8 case was interesting. I thought precisely because it was sort of it was like it was almost perfectly teed up for a conservative court. It was like not that it was trolling, but it's like there's this woman who's trying to avoid the death tax.
Right.
And she's getting death taxed, quote unquote, death taxed, only because her partner who left her her inheritance was a woman, and they're both women, and they were married. So and her marriage is not recognized by the federal government. So she was hit with this like $300,000 tax bill, and so it's like it's this the DOMA case I thought was interesting precisely because it's sort of tailor made to force the conservative justices to question. Whether it's their sort of federalism that wins out or their like cultural conservatism that wins out.
What better way to target conservatives' heartstrings than to say if you do what liberals want to do, it'll mean a tax cut for a bunch of people.
Right, a tax cut for a job.
Exactly.
A wealthy person. But when we got in the courtroom, it was actually. The conservative justices, aside from Kennedy, who seemed very skeptical of DOMA on federalism grounds, I wouldn't be surprised. Clarence Thomas, who's like the biggest conservative federalist guy on the court, I think he might rule against DOMA. Maybe that's something that people have speculated.
Yeah, I read about this yesterday.
Right, and certainly the other, and maybe you could talk about that a little more. Certainly the other conservative justices who spoke during the hearing didn't seem inclined to buy the whole federalism.
No, certainly not. I think Kennedy was there, but Roberts wasn't. I think, and Scalia and Alito certainly weren't. What really surprised me during the 2 days of oral arguments was the very clear antagonism from Chief Justice Roberts towards the challenges to both DOMA and Prop 8. He focused more on the standing issue on Prop 8, and he even had some standing issues with DOMA. But when it came down to actually talking about the merits, I saw no sympathy at all from him, toward the notion that gays should have an equal marriage right as straight couples do. So that was certainly a surprise. With regard to Clarence Thomas, I think he's very hard to predict. My efforts to try to get a good read on what he might do and where he's going didn't really amount to anything conclusive, because even the Federalist scholars who have come to the view that DOMA should be struck down as a violation of states' rights, people like Randy Barnett and others who authored an amicus brief with the Supreme Court saying libertarian conservative scholars who said DOMA violates states' rights, they admitted at the same time that there is a reason, that there is a rational basis or a compelling reason even for constitutional validation of DOMA apart from states' rights. So, and none of them would necessarily bet or put money on the notion that Clarence Thomas would rule against DOMA. But I think it's sort of a moot point anyway. If he does, it would be a huge surprise. And it would be a big deal, but if he does, I can't imagine him being the deciding vote either way.
Well, it's sort of interesting, right? I think it's an interesting question with Thomas because, there's this sort of, I think there's always been an argument about Scalia and Thomas, and I think people sometimes, I think, very patronizingly sort of suggest that Thomas is a Scalia clone, when I think sort of other people have made the argument far more convincingly, I think, that Thomas is the one who's actually influenced Scalia, because he's so uncompromising in his views. And I think, it would be interesting, I sort of expect Scalia to bend one way or the other depending on the result that he wants. But it would certainly be such, an interesting act of consistency for Thomas to rule against DOMA. I mean, I assume he would still argue that the government has a rational basis to discriminate against gay couples, in one case or the other. But he wouldn't. It would certainly be interesting if he took his consistency to that point and said, "But this law itself is very silly and shouldn't exist."
Right. I mean, I don't think it would be a contradiction for Thomas on the scale that Scalia has contradicted himself before on states' rights. For example, the Gonzalez versus Raich case in 2005, right. I think that's the best example I can think of, where Scalia ruled against libertarians and against, the Federalist Society wishes, and in favor of the federal government for broad federal power when it comes to prohibiting medical marijuana persons or medical marijuana licensed people from growing pot in their backyard. So when it's an issue, I think, that he feels very strongly about, as he calls himself a law and order conservative, Scalia is more willing to bend his jurisprudence to, reach a certain outcome. And I have not seen evidence that Thomas is willing to do that. I think validating DOMA would raise questions as to whether he's doing that, and I think there's a perfectly legitimate argument to be made for that. But as far as I could tell, and I'm obviously not the expert on this, and the experts on this say that that he could find a constitutional basis to do that without necessarily contradicting himself. So I suspect he might do that.
Yeah, I mean, and certainly it's not. If he does do that, it's not his fault. Like, if there are 5 votes to over, I don't think Thomas would be the 5th vote, right?
Yeah.
I think that if there are 5 votes, I think Thomas might be more likely to do that, because then he can sort of get his 2 cents in, and it's not like he's the one who's responsible for striking down DOMA. I was actually sort of surprised at Justice Roberts' behavior in particular, because at one point, he actually made the procreation argument. He's like, maybe it is, the link to procreation that makes marriage a fundamental right for heterosexuals, which is like a really weird argument for Roberts to make, because he has adopted children, and so it's sort of not to get real personal here, but I'm sure Justice Roberts doesn't think that he doesn't he doesn't have he doesn't have a fundamental right to be married or whatever because he's not going to have kids. Like, I think it was sort of shocking, and I think reveals to the extent to which Roberts was maybe more hostile to the same-sex marriage argument than I really expected.
Yeah, I thought the same thing. I thought throughout the 2 days, I was kind of surprised at how he wasn't. I expected him to at least tease on both sides a little bit, to suggest or to ask skeptical questions from on both sides, as he often does, because it's not always Kennedy, as we saw in the Affordable Care Act case. It's not always Kennedy who's a swing vote. And this is his court. He is the Chief Justice. This is going to be a very important part of his legacy, and everyone knows which way this is going. So I thought, given all of those considerations, that he would be, at least he would present himself as at least weighing both sides. But in reality, what I saw was not only strong opposition to the challenges against these laws, but a strategic effort to try to win over Kennedy in particular to his side.
Right. I mean, that was interesting during the DOMA case. Paul Clement, who's the former Bush Solicitor General who was arguing that case, he never made any of the sort of typical arguments that conservatives make against same-sex marriage. He never made any of the values arguments. He was never, he never argued that it would erode straight marriage. He never said that it had to be procreation. He stuck entirely. He was so super on message on the federalism piece. Right. And so were the other conservative justices. I mean, the most telling thing was that the conservative justices kept trying to trap the lawyers challenging DOMA into saying that there was a fundamental right to same-sex marriage in the Constitution, which they were trying to avoid saying, precisely for the purpose of scaring Kennedy away from wanting to rule that DOMA should be struck down.
Yeah, no, absolutely, and that was very notable in Chief Justice Roberts' questioning in particular. I remember one exchange between him and Solicitor General Verrilli, who was arguing against DOMA. The dynamic was particularly interesting because as a Solicitor General, you're never supposed to concede that the federal government should not do something, or you're never supposed to concede that a certain power is in violation, or a certain thing that the federal government does is in violation of federal power. So Verrilli stuck to the equal protection argument. Nobody was making the Federalist argument. There were 4 votes, it seemed, for equal protection, to strike down DOMA on equal protection. There were 4 votes, assuming Thomas was there. The conservatives wanted to uphold DOMA, and Kennedy seemed to be the lone person in the entire courtroom making the Federalist case. And what Roberts seemed to be trying to do was to get Verrilli to say, no, we don't have a federalism problem with this. He asked him 3 times. So, just to clarify, I just want to be very clear on this. Mm-hmm. You don't think there's any federalism problem with DOMA? And Verrilli flat out said, no, Mr. Chief Justice, we don't. And Kennedy didn't like that. That didn't sit well with him. He jumped in and said, wait a minute. Of course there's a federalism problem. Marriage is a province of the states. They're the ones who regulate and define it and who make decisions about that. How is this not a federalism problem? So what it seemed to me was that Roberts decided that Kennedy, especially after the oral arguments on Prop 8, when Kennedy made clear that he wasn't comfortable ruling on the equal protection grounds, he didn't want to go there. He didn't want to declare a constitutional right to marry. Roberts wanted to eliminate the federalism basis for striking down DOMA and to force Kennedy to rule on equal protection, knowing that would give the conservatives a chance to win him over. In other words, if Kennedy had a choice in saying you have to either uphold DOMA and possibly Prop 8, but you have to uphold DOMA or declare a constitutional right to marry, I think his thinking was, or his gamble was that Kennedy might be easier to win over to uphold DOMA. So it was a really interesting strategic move.
It reminded me a little bit of high school. Like there was something like you're either with the jocks or the nerds.
Right,
not high school, not my high school, but like there's sort of average sitcom high school, where there's sort of like the other justices were like Kennedy's like the kid who's like caught in between 2 social cliques and he has to decide who he really wants to be down with. It's really like, and there's a lot of like social intrigue that behind even the decision to take this case, which I think you wrote about a little bit. It's sort of come out that the liberal justices or the Democratic appointed justices, since most of them aren't actually that liberal, sort of didn't actually want this case to come to the court, and maybe Kennedy didn't even actually want it to come to the court, and that this was sort of a strategic decision by the court's conservatives. Maybe you could talk about that a little bit because you wrote about it.
Yeah, I think it's very much possible that the liberal justices decided or didn't really want to take a Prop 8 because if they did, they would introduce this notion of declaring a constitutional right to marry if you were to overturn one state's ban. The assumption would be other states' bans may also not be valid. So what it sounded to me like was that they weren't that thrilled about having to hear the case or hear the Prop 8 case, whereas the conservative justices knew that if you introduce the equal protection thing, and this goes back to what we were just talking about a moment ago, if you introduce equal protection, then you can't simply strike down DOMA on that grounds without also having to deal with the consequences of applying that same reasoning and that logic to Prop 8. So it seemed to me, and Adam Liptak had a really good piece about this in the New York Times as well, that the conservative justices, or the votes to grant cert on the Prop 8 case may have come from the conservative justices because they might have thought that this was one way to force Kennedy's hand.
Right, and they're like last best chance for halting the advance. Right. And I think, Scott Lemieux wrote about this. I think this is something that's underappreciated, is that people are saying, it would be better to do this like trench warfare for the gay rights movement, to do this trench warfare state by state by state, because then ultimately that right can't be taken away or something like that, or it's more legitimate. I think the problem is like, Scott Lemieux of Lawyers, Guns, and Money wrote this piece. I think it's really important. It's like public opinion. Like lawmakers don't actually follow public opinion that much. I mean, it's incredibly, it's certainly feasible for, like the anti-gay rights movement has lost the battle of public opinion, and for them to still forestall full rights for gay people for decades.
Right. Absolutely.
You know what I mean? For, like everybody sort of, there's like this complacency about, I think on the liberal side that, even if we lose this case, eventually everybody's going to get their full rights. And it's like, yeah, but that could take a really, really long time, and some people are never going to see them as a result. It's not just sort of, the sort of the backlash problem is like a problem I think you almost wish you had, because the problem of having to fight this through every state legislature in the country is going to be extremely difficult. It's not going to be easy just because the public is on your side. There's an amazing, the American system isn't one that's like amenable to like really rapid, radical change, right? I mean, there's lots of options, both procedural and political, for the people who are opposed to same-sex marriage, to sort of almost like have like a Stalingrad-esque defense of their views that lasts, that keeps this fight going for indefinitely.
And imagine if the courts did step in at some point, or there weren't a constitutional amendment. Right. How long would it take before gay couples in Louisiana or Mississippi are able to get married? So
right.
Yeah, I think that is an argument against complacency. On the other hand, the short-term thinking among political strategists in both parties is that it would be a winning issue for Democrats. Imagine if Democrats put gay marriage on the ballot in Ohio in 2016 to try to win that state, as President Bush did on the flip side, or on the other side in 2004. Right. That would be, I think Democrats would love to do that. So the political angle for Democrats is that there may be a winning issue for them, a wedge issue, since the winds are moving in the other direction now so strongly. But when you think about the people this actually affects and the actual impacts of this, I think gay couples would, across the country, would much rather have this issue settled nationally sooner rather than later.
Yeah, and I mean, there's sort of, there was this sort of weird moment during the Prop 8 case where, it was sort of funny because it almost felt like the arguments between Ted Olson and the justices were so familiar and friendly. It was like weird. It was like people arguing at a dinner table. But there's like this moment where Scalia says, when did it become unconstitutional to ban same-sex marriage? And Olson didn't want to answer the question. Right? And I thought that was interesting because, and I understood why Olson didn't want to answer it before this court. But I think it's actually not a hard question. I mean, Carolyn Fredrickson of ACS, was like, well, it became unconstitutional when we adopted the 14th Amendment. We just didn't realize it yet. And I think that's a stronger argument than I think people realize, because, of course, we had the 14th Amendment, we had the Civil War, post-Civil War amendments, and then there proceeded to be, another century of Jim Crow racist discrimination against black people, which the court upheld over and over and over again as constitutional. And they didn't do that because it was constitutional. They did it because their perception of what the Constitution actually meant changed. And I think that for Justice Scalia to say interracial marriage, banning interracial marriage was unconstitutional when the Civil War amendments became unconstitutional when the Civil War amendments were adopted. Well, that's fine, Justice Scalia, but obviously the Supreme Court didn't feel that way until 1967.
That was the weird part about that. I thought Ted Olson actually had the better of that exchange, or at least he could have. He had the better underlying argument, but he could have handled that better, and he could have been more persuasive and sort of laid down what he really thought about that. And his response to that was sort of suggesting at exactly what you mentioned right now, which was he responded with a question. Well, when did interracial marriage become unconstitutional? With the clear implication being it's always been unconstitutional. We just hadn't realized it. And then Scalia sort of barked back and said, "Don't respond to my question with a question. I'm the one asking questions here." And Ted Olson didn't quite say that, but that seemed to be very clearly where he was going. And at the end of the day, I do think this was sort of a dinner table-esque conversation, because that's not really. I don't think that's an exchange that is going to matter that much.
Right. It was funny because he was like, at first he was like, Scalia answered the question, and he was like, wait, I don't have to answer your questions. You answer my questions. It was like he forgot that he was he forgot that he's the guy in the black robe for a second. and Ted Olson's the guy who's supposed to be supplicating himself before him. But yeah, that was a really interesting exchange.
I think Olson just wanted to be cautious about that. He probably hadn't rehearsed that, and he didn't really want to wade into territory that wasn't necessarily going to help him, or necessarily going to help him win the justices he needed to win.
So one of the other sort of interesting things that was said, particularly by Roberts during the oral argument, was sort of this question of the gay and lesbian community being politically powerful, and this is relevant to the legal question because the United States government has been arguing that gays and lesbians should be a protected class because of a history of discrimination, political powerlessness, et cetera, et cetera. And Justice Roberts said, how can you be politically powerless? It seems to me like politicians are falling all over each other to join your side, which I thought was actually... I thought that was a really weird question, right? Because basically you're saying if a group has its rights stripped from it by a popular vote in state after state after state after state, and it organizes a political response to that, and that political response is effective, then actually, this question of the history of their political powerlessness doesn't actually matter.
See, the legal issue, or the legal rationale that Roberts was trying to get at with that exchange was that gays shouldn't be a protected class, according to him, which precludes the need to apply heightened scrutiny to laws that discriminate against them. So I think that was his reason for pursuing that line of questioning. But at the same time, I think it revealed, I don't know. The tone in which he kept demanding an answer to that question, say it, admit gays are powerful, admit they have powerful lobbyists. I think that sort of said a lot about where
it was almost like paranoid. It's almost like what you hear on like American Family Association radio, like the gay lobby and their secret influence, guiding everything. I mean, it was really weird.
And like I said, I think it was more strategic. I don't know that there was necessarily a lot of emotional hostility or whatever from Roberts, but it was clearly an effort to knock down a legal argument or to make it easier for these laws to be upheld.
Well, this question of animus is something that Roberts is really interested in, because one of the other questions that he kept asking was, did the legislators who voted for the Defense of Marriage Act, were they motivated by anti-gay bigotry? And both attorneys who were arguing against DOMA said no, but I think the answer is obviously yes. I mean, Elena Kagan said, she asked Paul Clement, is this what happened in 1996? Did Congress ban same-sex marriage out of disapproval of homosexuality? And Clement had this moment where he's like, "Oh no, that would be a terrible reason to pass the law." But is anybody who supports the law against that interpretation of events? Well, does anybody who supports the law think that homosexuality is not morally objectionable from their standpoint? I mean, no.
Well, she kind of proved her point, because a minute after that, she quoted from the House report at the time in 1996, saying something to the effect of, expressing their moral disapproval with gay marriage, or I don't remember the exact wording, but that was the gist of it. And I don't know. I mean, I've talked to other people who disagree with this, but to me that seemed to catch Clement off guard a little bit, which I'd never seen in any of the cases I've watched him in. It's really backing him into a corner there, because right now there's just no way you can argue reasonably, not even at the Roberts court, that it's acceptable or that morally it's legitimate to think or to think any less of gays.
This question, I mean, the other thing was that struck me about that Roberts question is that Roberts seems to ask this question a lot. He's very upset whenever anybody accuses anybody else of bigotry, unless he's accusing schools that try to integrate through affirmative action or public schools using busing programs. That he finds really offensive. But he's really offended by the suggestion of bigotry. So, I've seen him ask a version of that question in 3 cases now. In the Arizona case, it was the first thing he said to Don Verrilli. He was like, when they were arguing the Arizona immigration law, he was just like, one question: this isn't about racial profiling, right? And it's like, okay, like that was before it really even got started. And then in the Voting Rights Act case, he said, he asked really, is it your opinion that the people of the South are more racist than the people of the North? I mean, he's just like, he is like deeply concerned with the idea that it's like very I think Matt Iglesias coined it as anti-racism. That is like the accusation of bigotry outrages you far more than whether or not the underlying act of bigotry, the underlying description of the act of a particular act being bigotry is accurate. And it struck me particularly because in the DOMA case it was so clear. I mean, the legislative record is so clear that this was about, people's moral objections to homosexuality.
And don't forget the affirmative action case in Fisher, where he was pretty much he took a leading role in just pounding the very notion that affirmative action still has a place in society right now. I think this issue, the issue of race and culture and equality and so forth, he's coming from a place that I think sits very deeply with him. He feels very strongly about this stuff. He feels very strongly against the use of government to, how should one put this, appropriately, to use government to try to rectify past discrimination. He thinks that's illegitimate, quite simply, and that really flows through his thinking. In across issues, I think that's the legal issue that he feels most strongly about, this sort of cultural emotion.
Right. I mean, I think arguably the biggest legacy of the Roberts Court is ultimately going to be the sort of unraveling of the Warren Court, or not unraveling of the Warren Court, but the sort of bizarre Warren Court, where basically his biggest legal intellectual project is the elimination of the core elements of the civil rights laws that were passed in the 60s and 70s. This sort of all of those laws that were designed to prevent and rectify discrimination, he thinks are unconstitutional for one reason or another, or if not just unconstitutional, and as bad as the thing that they were rectifying.
I think that goes well beyond the Warren Court, though. I mean, the affirmative action case, the decision was made in 2003 in Bruder versus Bollinger, made by Sandra Day O'Connor. It was just a couple of years before he got on the court, and a decade later, the majority decision said we should keep these policies in place for 25 years, and he wants to get rid of them within 10 years. So, I don't disagree with you on the fact that a lot of the stuff that he does want to unravel, and a lot of the stuff that does that he disagrees with, that's woven into law right now, emanates from the Warren Court. But yeah, I think it goes beyond
that. As far as I think you made your prediction earlier, but how do you think ultimately the same-sex marriage cases, the Prop 8 and the DOMA cases, are going to shake out?
I think what's the result of this is going to be, like I said, Prop 8 gets kicked down standing, so the case gets kicked down standing, so Prop 8 gets struck down. The issue of same-sex marriage is left to states, but DOMA is also struck down, so the federal government ends up having to accept whatever the states think. In other words, the federal government can't treat married couples in one state, gay married couples in New York, for example, as any less than straight married couples in any other state when it comes to things like retirement benefits, Social Security, tax benefits, and so on.
Okay, I have a really poor track record with Supreme Court predictions, having thought that the Affordable Care Act was going to get struck down. So I'm going to say that I think you're probably right about that, about how that's going to shake out. It's certainly after reading a lot of analysis of the court and seeing the way things were going. But Sahil, thank you so much for coming on Adamize. I appreciate you taking the time to come on here.
Absolutely, it was a great chat.
All right, thanks a lot. Take care.
Bye.